begs one question as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Could 370, which was envisaged to be a temporary provision, be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Well, the Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself?
No.
To convert the character of 370?
All right. Now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Madam. In fact, Muzaffar Beg says we didn't even know about it. That's why I want to read Muzaffar.
Mr. Sibal, there are two ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And we also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Malaj, that it is
not. Or was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Malaj, that it is amendable for the sake of argument. Then, Malaj, how is to be amended? The Constitution must provide a solution, no, Malaj? I'll assume, Malaj, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?
Once we concede, Mr. Sibal, that concede in the sense for the purpose of the hypothesis. We're not putting anything in your mouth, not at all. So I don't misunderstand that. Once we accept the fact that 370 is subject to the amending power under 368, then equally 370 provides for a modality through which 370 itself would come to an end.
Well, let's see 370 then, Malaj, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition through an executive act under 367(1). Then, Malaj, we have to find the modality within the Constitution, not outside it, not vested in an executive power of the Union. That cannot be. So if your lordship puts to me, and rightly, that something more had to be done under the Constitution of India, we'd like to know what is that something more.
But 370(3) itself specifies the conditions in which the abrogation can take place.
Which is the Constituent Assembly it must be on the recommendation of the Constituent Assembly. So it gives the solution. That is in line with the federated nature of this provision. This is complete federation, whereas we are quasi-federal qua other states. But these are purely federal qua Jammu and Kashmir, because the residuary power vests, Manoj, in the state. So if you say, Manoj, that C70 sub-article 3 provides that solution, but that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go that far. I'll assume that there is some power available. It may be 368. Let's say, it's hypothetical. We're not concerned with it.
No, Mr. Sibal,
Maybe
no,
it's-
no, when you argue, then we'll have to take one. 360 is power to amend the constitution. That's certainly there.
Yeah.
Now, when we look at 370 clause 3, now the issue would be whether 368 power is still available to amend the constitution.
But your lordship is not concerned with it in this matter.
No, it is. It's very, very crucial. Because once we accept the fact that Parliament as a sovereign lawmaking body has the power to amend everything, including 368,
Yeah.
370.
including 370,
Yeah.
then any amendment of 370 may be subject to criticism on the ground of morality, but not power.
No, but it's not an action.
Maybe it's a political argument, but not a power. It's not an argument of constitutional
This is
power.
not action under 368. Your lordship is not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. But is it an argument of the absence of power?
Where is that in 370?
And the
that
court
power?
the court is concerned with either the existence or the absence of power, right?
Not that I should ask your lordships, where is that power in 370 that says that 368, you can do it under 360?
So 368 is the power to amend the
But
constitution.
we are not, are we concerned with that here? I'm sorry, Malaj, you require 2/3. You represent.
There are independent avenues. You have the power to amend.
Malaj,
You have the power within 370 to abrogate.
But Malaj, in that independent avenue must conform to the provisions of the Constitution. Well, an independent avenue derogates the provisions of the Constitution, is no avenue at all.
Mr. Sibal, for the timing, if we ignore the proviso to clause 3, in fact, the clause 3 itself, independent of the proviso, gives the power to the president itself to abrogate 370. If
No,
we forget about the
Sorry,
proviso.
I'm sorry to say that, Malaj. I'm really
Just
sorry.
read three-
There is a
just read it
proviso.
once again. Just read
You
it
can't
once again.
exercise that power without the proviso.
No, the proviso is something different. We are examining the proviso independently. But independent of the
That-
proviso,
the Clause 370 comes into play on the recommendation of the Constituent Assembly. Your lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the president will exercise power, not the other way around. That's why I said you can't even initiate a bill. Your lordship will remember that. You can't even initiate a bill. Forget about anything else.
Another problem is that then we would be redrafting the substantive part of clause 3 to postulate that the power under the substantive provision of clause 3 can be exercised so long as the Constituent Assembly of J&K is in existence. In which case, will the proviso not swallow up the main provision?
But that's what it says, that unless that recommendation is there, you can't exercise your power. President can't exercise power under 370, sub-article 3. It says so. Well, you'll have to interpret it on its plain terms, Bharat, and the lordships have said it not once but several times over. And it's a provision which, in essence, is a provision of federalism. It's at the heart of federalism, is this, Bharat. Yes, of course, it's a precondition. There's no doubt about it. I mean, whatever sophistry may happen, can't happen in this way, Bharat. And whereas 373 power has been exercised by the Constituent Assembly, saying no recommendation. And I'll come to your lordship's judgment of Sampath Prakash Maharaj, which actually deals with this issue. So let's be clear, Maharaj. Sorry.
Where does the Constituent Assembly specifically says that it doesn't the sub-article 3 will not apply to the. It only says that it only exercises the 3 choices. First, as to whether it should accede to the Pakistan or to India or to remain independent. So out of 3, it decides that it will accede to India. But where does it specifically say that it recommends that sub-article not be available?
Let me just, let's go back, Maharaj, to 1950, 26th of January. Right? There was no Constituent Assembly. In fact, there was no decision. Originally, it was a National Assembly. There was no decision to convert it through adult suffrage into a Constituent Assembly. So Parliament, forget about the government, Parliament incorporated in 370 the provision for a Constituent Assembly. I asked myself this question, why? Why did Parliament do that? Parliament, there was no Constituent Assembly in place. There was only a National Assembly. This must have happened in collaboration with Jammu and Kashmir. Must have happened, Mullahs. That's why the term Constituent Assembly was included in 370 sub-article 3. Now, when they said in the proviso that it's on the recommendation, there was no Constituent Assembly. So it had to be a temporary provision. It couldn't be a permanent provision. And the preamble of the Constituent Assembly says to further define the relationship between Jammu and Kashmir and India. So it was temporary because there was nothing in place. It was not temporary because this provision had to go. No. And therefore, Mullah, that relationship was to be decided by the Jammu and Kashmir Constituent Assembly, which had to affirm all laws that had been passed. Even the laws could not be passed till such time it were ever confirmed during this period by the